Hope you are doing well. I am making these mini lectures on federalism fairly late at night. It's kind of quiet, and so if my eyes look kind of heavy and I look kind of tired, I am. But this lecture is for me a really intriguing one, McCulloch versus Maryland. Keep in mind that I told you in the last mini lecture that John Marshall was the Chief Justice who decided, along with his fellow justices, the case of McCulloch versus Maryland. But John Marshall was a believer in the nation-centered view of federalism. He was a believer that the national government does, in fact, have vast implied powers. He believed in national supremacy. And the case of McCulloch versus Maryland is intriguing, not only because it is considered one of the 10 most important Supreme Court cases ever decided in the history of the United States, but this case has tentacles that go back essentially to the beginning of the Republic. And here goes. There was a huge battle within George Washington's administration about whether or not the U.S. government should charter a national bank. The Bank of the United States was Alexander Hamilton's brainchild. Alexander Hamilton was America's first Secretary of the Treasury. Alexander Hamilton was George Washington's most trusted advisor. Alexander Hamilton, of course, believed that the Bank of the United States was in fact legal. He believed that it was necessary and proper, that a national bank was necessary to help facilitate large capital projects that state banks simply did not have the capital to help finance these large projects that had national implications. And therefore, not only would a national bank help carry out the interstate and commercial flow of money, it would help facilitate a modern industrial commercial American society. And so Hamilton became the architect of the Bank of the United States and its most ardent supporter. The followers of Alexander Hamilton who believed in the Bank of the United States organized themselves and formed America's first political party called the Federalists. So America's two-party system has its origins with this Bank of the United States. So you can already see this case is more than about American federalism. It has political implications. As you might imagine, the bank had a lot of critics. And the loudest, most outspoken critic against the Bank of the United States was America's first Secretary of State, Thomas Jefferson. Excuse me, my eyes are itchy. And Thomas Jefferson believed that banking was a power that belonged to the states, that the U.S. Constitution did not give the authority to the national government to charter a bank, and therefore this bank was illegal, it was unconstitutional. And Thomas Jefferson's supporters quickly mobilized in Congress, and Jefferson's supporters became known as the Democratic Republicans, and of course, today we call them the Democrats. So this project, even before the Supreme Court case, even in terms of the debate over whether or not the bank should be created, had high-powered opponents. Alexander Hamilton and his supporters forming one political party, the Federalists, and Thomas Jefferson and his supporters forming the Democratic Republicans. Now, George Washington, our first president, liked to think of himself as above parties. In fact, George Washington called political parties baneful and said that he did not belong to one. George Washington tried to stay above the fray and not get involved in these political disputes. But in this case, George Washington did something that he often did not do. He involved himself in a political controversy. As your notes point out, George Washington ended up backing the Bank of the United States. And as soon as George Washington said that he was a supporter of the bank, you can imagine what happened in Congress. The Bank of the United States was passed, and in 1816 the bank was rechartered. One of the banks that appeared after the second chartering of the Bank of the United States in 1860 was a bank in Baltimore, Maryland. Now, Maryland had been a hotbed. Remember Luther Martin, my old attorney friend, right, who was the best known anti-federalist in Maryland. The state bankers go absolutely crazy when they find out that a national bank is going to appear in Baltimore, and the obvious reason is that state and local bankers simply believe that they are not competitive, that state banks, local banks are not going to be able to compete with this national bank, and that this national bank might drive them out of business, or at least might really diminish their profitability. So because state and local bankers in Maryland feared the size, the power of this national bank, they lobbied very hard local legislators who actually ended up levying a $15,000 a year tax on the Bank of the United States. Now think about what that means. In this particular case, the state of Maryland was going to tax the U.S. government. So tax collectors go to the bank. They seek out the head cashier of the Baltimore branch. That was James McCulloch. They say, "We're here to collect our taxes." And you can imagine Mr. McCulloch's response. He's like, "Are you kidding me? We're the U.S. government, man. What are you going to do? Are you going to go down the road? You're going to tax Fort McHenry, our military fort? You're going to go down the street and tax the U.S. Post Office? We are a national institution, and we are tax exempt. Get the hell out of here." And the tax collectors say, "Well, we'll see you in court." And McCulloch says, "Bring it on." So this case appears before the U.S. Supreme Court. And remember what I told you about justices and judges earlier. Judges and courts, these are umpires. They are umpires that resolve disputes. And in this case, we have a very high-powered dispute between the state of Maryland and the U.S. government. If you follow along in your notes point out that there were two issues in this case. Now, in reality, there are more than two issues in this case. But these are the two issues that are most important, and these are the two issues that are really discussed at length. So the first question that John Marshall and the U.S. Supreme Court have to resolve is, did Congress have the right to charter a national bank in the first place? Is this bank even legal? Or is this a function that belongs only to state and local governments? If you're following along in the notes, your notes are quite clear. John Marshall, remember, believes in national supremacy. John Marshall believes in that supremacy clause. He believes in that necessary and proper clause in Article 1, Section 8. Marshall ruled that Congress could charter a national bank, and here's where I want you to put multiple stars. The reason that this is so significant is that for the first time in American history, the U.S. Supreme Court endorses or establishes the doctrine of implied powers. In other words, what the U.S. Supreme Court said for the first time in McCulloch versus Maryland was that the national government has powers, vast powers, that extend beyond the literal language of the Constitution. So you need to know in this particular case that the reason that McCulloch versus Maryland is so important is that it established the doctrine of implied powers. If you've been reading your textbook that is accompanying this section, in chapter 3 on federalism, your book goes into a lot of detail about a case after McCulloch versus Maryland. It's the case in your book called Gibbons versus Ogden. And in Gibbons versus Ogden, you have the same controversy. It involves the licensing of steamboats. And in this particular case, we have the state of New York and the U.S. government both making the claim that they are the one that is the supreme actor in this area. And just like in McCulloch versus Maryland, John Marshall backs the U.S. government. He, remember, is a believer in this nation-centered view of federalism. So the first question, does Congress have the right to charter a national bank? Yes. It is an implied power of the national government. And so because Congress did have the right to charter a bank, there was a second issue, a second controversy. And the second controversy was, did the Maryland state legislature pass a law that was legal? In this case, was it legal for the state of Maryland to tax the bank $15,000 a year? And in this case, John Marshall ruled that Maryland could not tax the Bank of the United States because the power to tax involves the power to destroy. And essentially what the argument here was, if we allow the states to determine tax rates on national institutions, the states can impose tax rates that could bankrupt the national government. If, for example, this $15,000 tax was legal in Maryland, could the newly proposed $50,000 tax in Illinois, would that be legal? And if that were legal, could South Carolina impose a $1 million tax on the bank? And so Marshall ruled no, that in this case the prerequisite for American federalism was the survivability of all of its actors. In other words, at a bare minimum, we needed to ensure the survival of both the states and the national government, and the states could encroach on that survivability and security of the national government by potentially taxing it into extinction. Now, I think that's probably an exaggeration, but in this particular case, this case is incredibly important, and it establishes the notion of implied powers, of national supremacy. It takes a very, very broad interpretation of the Constitution. In 1835, John Marshall dies, and we have a very controversial president in 1835. Probably the most controversial president up until that time period. His name was Andrew Jackson. Andrew Jackson took a state-centered view of federalism, although he did not believe in state succession. So when South Carolina threatened to secede while he was president, he threatened to send federal troops in. But one of the most significant things that Andrew Jackson did was that he nominated John Marshall's successor. When John Marshall died, Andrew Jackson nominated Roger Taney. Roger Taney came from a slave-owning family in Maryland. Oh, payback, you know what payback is. And so Roger Taney is going to take a very, very different view of federalism. He is going to embrace a totally different view called the state-centered view of federalism. And we will talk about the state-centered view of federalism in the next mini lecture. Have a wonderful day.